pass you on to Geraldine.
Brilliant. Thank you very much, Gemma, and welcome everybody to this brief overview in terms of NEC4. The first few slides in the pack, as normal, are a little bit of marketing information about the company I work for. So we provide support to an engineering and construction industries across the board to all levels of the supply chain. We are the market leader in expert witness, planning, commercial, and technical matters. Obviously, a huge amount of our work is dispute avoidance, and that's the purpose of today. And also, of course, if things do go wrong, we can assist with dispute resolution as well. Established in 1978, and we are stock market listed. We've over 500 staff working worldwide. I've got a map there on the screen in front of you showing our UK offices. And of course, we are on a reduced capacity of staff in terms of people working in the office at the moment. My normal place of work is Hooton in Cheshire. But obviously, like most of you today, I'm also at home. In terms of the business itself, there's three parts. Driver project services, we provide quantity surveyors, project managers, and planners onto live construction sites on a short, medium, or long term basis. I work for Driver Tret, the part in the middle on the screen in front of you, and we provide contract advisory services, commercial and contract management, planning, programming, and scheduling, and of course, dispute resolution as well. Finally, Dialis is our expert witness division, and we can provide experts in quantum, delay, and on technical aspects. And we also have adjudicators and arbitrators as well as mediators within the organisation. Obviously, there's a vast way in which Driver Track can help your business. I'm just going to point out a few here. Contract reviews are a huge part of our business, making sure that those involved in the supply chain are clear on what they might be letting themselves in for. And I will point out a few issues that I've come across in the last few weeks in terms of mistakes and errors and problem contract clauses that you might spot. Obviously, we get involved in drafting notices, of course, COVID notices being one particular example, looking at payments, applications for payment, payment notices, pay less notices, and of course, looking at compensation events, extensions of time, and loss and expense as well. Finally, not only do we do training such as this for organisations such as Seeker, but we also do in house training as well. We've recently brought out our latest issue of the Driver Tret Digest. That's available for free on our website, or you can do that thing with your smart phone and the QR code, or quite simply email the marketing department. I know that I've come across quite a few of you in the past. Normally, when I'm doing these sessions live, I do tend to get a few boos at this point, but obviously, I can't hear you for today, so that's quite nice. So, yes, my background is as a quantity surveyor. I've got a degree in quantity surveying and I'm chartered. A lot of you I know are sitting in that main contractor position, and that's my background as well. I expel for BT, sitting there as a site QS. I went on and did my law degree, finished in 2002, and also my solicitor's exams, which I finished in 2004. And I've been in construction claims consultancy for over 20 years. So, well, let's start off with a little bit of background in terms of the NEC in general. If you look at some of the documentation surrounding the NEC contracts, you will see phrases like, it is a toolkit to stimulate effective project management. And it is very important to note that the contract contains very prescriptive procedures in the contract which must be followed. I can't say strongly enough how heavily into programming this particular contract is. And there's many clauses to do with risk management and forecasting as well. If I was looking at pricing an NEC contract over an ICC or over a JCT contract, I would certainly expect to be putting more in the prelims side in terms of the main contractor's site management, because this contract does require additional levels of administrative support, not just on the programming and planning side, but also in the correspondence that the parties have to send to each other. One aspect of the contract that is quite unusual, but it permeates through all of the editions of NEC, is the word prospective. Now, this does put me in mind of probably Australia in the 1800s and people digging for gold. But essentially, what it means in this particular context is that when you are looking at changes to the contract, which of course are called compensation events, you are looking at that from a forward looking aspect. Most construction contracts look at these compensation events or variations on a backward looking method. So, in other words, what have you actually spent? What has been the time implication? The NEC is all about looking forward. And certainly, from my perspective, that's where some of the issues arise. Now, in presenting this short seminar on NEC, and in particular NEC4, it is worth pointing out that there isn't just one version of NEC4. The original document was published in June 2017. Amendments were put together and introduced in January 19, and then further amendments were introduced just over a week ago, so the October 2020 set. All of the amendments available for free from the NEC website, and it is hugely important that you know which version that you're working on. Is it NEC4 June 2017, or is it both sets of amendments, or just one set of amendments? Really, the January 2019, they are seen as tweaks, but they are important. And making sure that you've got certainty on the set of amendments which apply is vitally important. So, again, a little bit of history. Why was NEC4 introduced? I mean, essentially, an awful lot of organisations have stuck with NEC3. Um, and there are five main reasons that have been put forward for the introduction of NEC4. Changing requirements of users, and certainly one that I was very, very pleased to see was the introduction within NEC4 in relation to the use of email. Such an obvious thing. All of us are using email all of the time, and NEC4 now addresses that, which is good. It is to further stimulate good project management and to improve clarity and simplicity. They also wanted to see the different NEC contracts, so between the supply contract or the professional services contract, as well as the main and subcontracts, they wanted them to essentially feel more like a family. So that rather than having works information in the main contract and scope in the supply contract, they put the same type of terminology across the board. The other change is the fact that the contract is now gender neutral. You will not see the word he within the contract, and there is more use of the word client and contractor instead. So, these changes in terminology, they are tweaks, but again, if you're writing letters, sending notices under NEC4, then of course it's a matter of good practice to make sure you use the right terminology. So the employer is no longer, and that has become the client. Works information has become scope, again, across the board. The risk register has become the early warning register. The word risk has changed to liabilities. The final one I've listed there is a little bit more difficult to see. So we had the shorter schedule of cost components, and that's now become the short schedule of cost components in NEC4. So that's certainly a little bit of tweaking and really doesn't go to the heart of the contract. Now, I appreciate that this seminar is essentially aimed at the foundations part of Seeker. So just a reminder as to how the contract goes together. And this is the same for NEC3 as it is for NEC4. I like to think about this as a little bit of a pick and mix in a sweet shop. So you have the core clauses that apply across the board. And a good example of that, of course, would be 10.1, where the parties are working in a spirit of mutual trust and cooperation. You then have one of six main option clauses: A, B, C, D, E, or F. And in my experience, the two most common, of course, are options A and then option C. You've then got up to 20 secondary options, which cover the W's, the X's, and the Y's. And actually, I'm also going to add the Z's in there. And then, of course, there's a partnering agreement as well. So, just briefly, first of all, looking at the W's. And obviously, I sincerely hope that none of you get to have a little practice with the W options, because essentially this is the dispute resolution clauses. W1 is where the Housing Grants Construction and Regeneration Act does not apply. However, NEC thinks that adjudication is the right way to resolve disputes. And so W1 confirms that adjudication will apply, but it's where the Construction Act doesn't apply to the scope. W2 is by far the main version of dispute resolution that we see, and that's where the Construction Act does apply. And again, adjudication does also apply here. W3 is certainly evidence of the NEC wanting to be more attractive to international markets. And essentially, what it's trying to do is steal some of the market share from FIDIC. So, dispute avoidance board is where essentially there is either one or sometimes three people that sit right from the start of the contract. And as and when disputes come up between the client and the main contractor, they can put these disputes across to the dispute avoidance board for a decision. Ideally, of course, those three or one person would sit there and do nothing for the whole of the contract, but the idea is that they become very, very familiar with how the contract works, and disputes should be avoided or resolved far more quickly. So that's the W options. Most common by far, in my experience, is W2. We then have the secondary options, and I've highlighted there, bold and underlined, the new ones that have come in relation to NEC4. So I'm not going to run through all of the items here. I'm only looking at the new ones under NEC4. So the first one to look at here is X4. Of course, PCG stands for Parent Company Guarantee, and they've tweaked the wording here. It's no longer a parent company guarantee, it's instead a ultimate holding company guarantee. There was a feeling in the industry that, particularly with the very large main contractors who had quite complicated structures, that the guarantees that they were getting were from a further intermediary company rather than from the company at the top of the tree. So the ultimate holding company guarantee means that now the old parent company guarantee has to be provided right at the top. X8 covers undertakings to the client or others. Again, another new area. Essentially, what we would generally call this within looking at construction contracts, of course, is collateral warranties. And I do have some notes on that to go through in a couple of minutes. X9 covers transfer of rights, which is all about copyright. X10, of course, we would know this as BIM. They've used the terminology here, information modeling. And X11 covers a new right for the client to terminate at will. So if I just pause there and go back and look at this X8, because this is a new part of NEC4. So if I go back to NEC3 and indeed NEC2, there was no reference there at all to collateral warranties. And having Z clauses about collateral warranties was very, very common, particularly, I will say, in building projects. NEC4 doesn't use the phrase collateral warranty, but instead refers to undertakings, which is a term more commonly found internationally. And these undertakings, or as we would say, collateral warranties, fall under two categories. The first one is a collateral warranty from the contractor to others. Now, of course, there is no need for a collateral warranty between the contractor and the client because the contract already exists. This is where the contractor is going to provide a warranty to a funder, a tenant, or a purchaser. Not so common generally in civil engineering, unless you are looking at potentially a project, let's say like the Mersey Gateway Bridge. The second version is between a warranty between the subcontractor to the client, because of course there is no direct contractual link there. And then, of course, extending that further between the subcontractor and again the tenant, funder, or purchaser. I've quoted in the notes, and of course, you are more than welcome to get a copy of these slides at the end of the presentation. I've quoted there the extract from X8. So you can see at X8.1, the contractor is going to give undertakings to others as stated in the contract data. And it's very common within the NEC contract that in many cases, for the answers, you have to go back to contract data part 1 or contract data part 2. And the clauses in the rest of X8 are, as you would expect, in relation to the other undertakings that are going to be given. I've also put in the notes the extract from Contract Data Part 1. And so essentially, who the warranties from the contractor are going to be provided to. So you could see written there NatWest Bank, or indeed whoever is going to own the structure at the end of the day. And then again, you can see reference there to the subcontractor undertakings. So this could say any design work provided to the employer, and then again, any design work provided to the others. So, all very good that they've introduced these clauses in relation to collateral warranties, but what they haven't as yet done is actually put forward a format of the collateral warranty. And essentially, what some clients are doing at the moment is they're essentially pinching the JCT versions, or alternatively, they are having their own bespoke warranties written. Now, essentially, there's been no change from NEC3 to NEC4, apart from the fact that we haven't got as many Z clauses because we still have no standard form of collateral warranty. Do take care at tender stage on reviewing these collateral warranties because they can be onerous and they can increase your liability. So they do need careful checking. So with the rest of these X clauses then, X12, multi-party collaboration. Of course, we would have called that in the past partnering. X15 is a tweak in relation to design liability. And the next slide I go through is going to look at X15 in a bit more detail. And we have two new X's here, X21, which is about whole life costing, and X22, which is about early contractor involvement. My view is that I'm not expecting to see X21 and X22 used wholesale across the board. But let's wait and see what happens as and when the contract actually becomes more common in terms of use within the industry. So going back to this issue of X15, and I have lost count of the number of times people have said to me, NEC our partnering contract. Well, certainly there are parts of the NEC contract which do feel like a partnering contract, but this particular example is the absolute opposite, in my view, of a partnering contract. If I just describe in a little bit of detail what this particular clause is all about. If a client and a contractor decide that the contractor is going to do some work and the contractor is going to have design responsibility, if they don't talk about the level of design responsibility, the courts would imply that their design responsibility is fit for purpose, which is effectively like a guarantee. I guarantee that my design will work. Now, in my experience, contractors' PI insurance would not cover them for a fit for purpose liability. And what you see in the vast majority of other standard forms is a core clause that says that the contractor's design responsibility is reasonable skill and care. So if you were, for example, to look at JCT contracts, around clause 217, there's a clear clause there that says if the contractor does any design work, his liability is the same as the architect or the same as the engineer, essentially reasonable skill and care. That's not the case with NEC contracts. The position, if X15 is not chosen, is that the contractor is automatically on a fit for purpose liability in relation to its design. And it's only where X15 is chosen that the liability moves down to what I would expect to see, which is a level of reasonable skill and care. So, certainly, a takeaway point from today's session is to make sure that for every contract you enter into up the line, if you're a main contractor with the client, or if you're subcontractor up the line with the contractor, that X15 always appears. Now, there is a tweak between NEC3 and NEC4. There has been essentially a reversal of the burden of proof. But remember, this only applies if X15 is chosen. So under NEC3, it was the contractor's duty to show if there was a particular design defect that had arisen, it was the contractor's duty to show that they had used reasonable skill and care in carrying out their design. Under NEC4, if there is a design defect, it's the client's responsibility to prove that reasonable skill and care was not used. Now, it is an important tweak. And I think if I have my main contractor hat on or my subcontractor hat on, this is a good change. However, I have to admit that I'm very disappointed that this is not a core clause within the NEC suite of contracts. And again, I'll say this probably is in my top three items when I'm doing contract reviews to check that this particular clause has been chosen. The other thing I want to point out in relation to X15, and I think this is a great addition to the contract, and I would give JCT a nudge on them including this as well, is that there's now a period for retention. I think my only disappointment on this is that, again, I don't know why it isn't a core clause. And again, it is a question that I am asked regularly. For how long, after a job is finished, do we have to retain documents? And the view goes anything between a year and infinity and beyond. If the contract is a simple contract, then my view would be an absolute minimum of 7 years. So, in other words, 6 years plus one. If it's a deed, absolute minimum of 13 years. In other words, 12 years plus one. However, that only covers contractual liability. And if you think about issues such as asbestosis or white finger, there is the possibility of a personal injury claim for an awful lot longer. What this particular new clause does, but remember it is only applicable where X15 has been chosen, is that the client can actually state for how long you are going to keep all of the records in relation to the contractor's design. So it will be interesting to see if this is chosen and what the period is that's stated. My view, and if I was advising a client, I think I would struggle to go for anything less than 20 years. Um, I have to admit that I do have a few floppy disks around the office. Not the I think it was 5.5, but more the 3.25 inch. I don't think I've got a piece of technical equipment to open those now. So, how we're going to get rid of obsolescence on this, again, is another question outside of the scope of this webinar. Okay, we've looked at the changes on the option clauses. If we now look at some of the changes to the core clauses, and again, some of this is actually not too important, and other parts are actually very important. We can see that there are some changes to defined terms. So we've got a corrupt act, which think sounds brilliant. Risk register becomes the early warning register. We've also seen the change from the works information to the scope. And there is also a tweak on the definition of a subcontractor, a person or organization who has a contract with the contractor, not just for construction of the work, but also here for design as well. This issue of a corrupt act, again, you read the contract at first and you think, why on earth did they just not refer to the Bribery Act? Well, of course, again, this is all about the NEC appealing to a wider international audience. And the Bribery Act is our main piece of legislation, but of course, they use different terminology in other jurisdictions. I'm not going to read out all of this because I'm sure the vast majority of people on today's webinar are familiar enough with the content of the Bribery Act. I'll just point out 18.1. I just think it's a great use of English. It says, the contractor does not do a corrupt act. I think again this just lovely use of present tense English here that does actually feel quite awkward to us. 18.2, the contractor takes action to stop a corrupt act of a subcontractor or a supplier. I'm just quite wondering how, drop that brown envelope. 18.3, just a point, you do need to update your standard subcontracts here if you're not using NEC4, again, to make sure that equivalent provisions are included down the line as well. So, one that I've mentioned earlier is this issue of communications, and this does get a huge thumbs up from me. First of all, 13.1 has been simplified. Rather than listing out all the different types of communications, 13.1 simply says each communication which the contract requires is communicated in a form which can be read, copied, and recorded. Writing is in the language of this contract. So there's no real change here to uh, the importance of this particular clause. Verbal instructions are still not permitted. Now, when we look at the contract data, however, this has changed. You can see their reference as normal to the client, their name, their address for communications, but we've also now got an address for electronic communications. It doesn't just say email address, it's wider than that. And when we look at clause 13.2, we're now talking about communication systems here. It says if the scope specifies the use of a communication system, a communication has effect when it is communicated through the communication system specified in the scope. Again, you can see NEC can be quite awkward with its use of English. So I am expecting now under NEC4 contracts to see a section in the scope, not just setting out the thickness of the concrete or the type of the concrete, but also to have a section on communication systems. Will it be some kind of DMS, document management system, a viewpoint or ACONX or something along those lines? Or will it simply say use of email? Again, that's going to be bespoke to every contract. The second part of the paragraph here says if the scope does not specify a communication system, a communication has effect when it is received at the last address notified by the recipient for receiving communications, or if none is notified, at the address of the recipient stated in the contract data. Now, I think there could be a little bit of confusion here. It doesn't say at the electronic address of the recipient stated in the contract data. And I think the wording could have been a little bit tidier here. However, NEC4 is streets ahead of all of the other standard forms on this, so they have made a good start. My view, and I think I am being probably a little bit paranoid on this, I would like to see a communications protocol included in the contract which specifically says what documents can be sent by email and what still has to be sent by snail mail or post. Okay, a couple of slides now just on risk management, and certainly something that is unique or was unique to NEC contracts was this early warning system. This didn't appear at the time in any other contracts and is essentially an NEC invention. Under the NEC4 contract, of course, we can see that the early warning system is still in place, but we no longer have a risk register. We now have an early warning register. And the key thing I want to draw your attention to, which actually is the same under NEC3 with just slightly different terminology, is that it's the project manager's duty to drive the early warning register. In my experience, what tends to happen is that the project manager doesn't take control normally of this spreadsheet, and it is essentially adopted by the contractor, who then is the person that's actually trying to keep this up to date. The duty does belong with the project manager, but if the PM isn't doing their job, then yes, I would recommend that the contractor does take that on. 15.2 is more prescriptive. Again, it talks about the project manager preparing this early warning register within a week of the starting date and issuing it to the contractor. And we can also see through NEC4, and I do wonder whether there's a slight groan here, more meetings. Okay. It says the project manager instructs the contractor to attend a first early warning meeting within 2 weeks of the starting date. So straight away, we are into a regime of having meetings. Now, this is a mandatory requirement under the contract, but it doesn't say what happens if that meeting doesn't take place. But remember, this is a prescriptive contract with lots and lots of procedures in there. It goes on to say that later early warning meetings are held as and when required, but importantly, at no longer interval than that stated in the contract data. I think that there is a sense in adding this early warning meeting to the normal progress meeting that takes place on site. So putting it at the start or putting at the end of an existing meeting. And again, you can have other parties attending this early warning meeting, such as the subcontractor. So nothing really too exciting here in terms of the changes, more a slight increase potentially in the number of meetings that have to take place. As I said right at the start, programs are a huge part of the NEC contract. And one of the things that I think that really frustrates me, again, when I'm working for a contractor, is generally main contractors have a good rate of success in having their first program accepted. And suddenly it looks like a COVID graph going from May and June over the summer in terms of cases. There is a massive fall off in terms of the acceptance of programs. And essentially, I'm going to blame both parties here. Contractors don't necessarily put all the detail on the program that the contract requires, but if they did that, it probably would be pretty unintelligible. And also, the project manager just does not really like to accept the program because they're worried they might be shooting themselves in the foot. NEC has recognised that this is a problem. They've put more information into clause 31.2, talking about the format of the programme must be stated in the scope. Again, we are seeing scope creep here, not just talking about communications, but now talking about information on how the programme should be put together. And probably the clause there's been the most flag waving about is at 31.3, which is, I've referred to it here as a deemed acceptance protocol. And I think in theory, this again gets a thumbs up from me. Let me read it out to you. It says, if the project manager does not notify acceptance or non acceptance within the time allowed, the contractor can notify the project manager of that failure. If the failure continues for a further 1 week after the contractor's notification, it is treated as acceptance by the project manager of the program. So, in other words, contractor submits their program and there's silence. The contractor says, hang on, mate, you haven't actually accepted my program. If the silence continues, the program is deemed to be accepted. I'm sure I just heard some people shouting out, it will be Zed. And I absolutely agree with that. I can see that whilst that's good in theory, most employers, most project managers will just put a line through that contract as part of the contract amendments. Couple of other tweaks here, and not too important, just really a change in terminology in relation to revised programs. There are some good changes in relation to payment as well. We can see in clause 50.1 that valuations continue under the main contract, which is a single black box, up to the supervisor issuing the defect certificate or up to the termination certificate being issued. And in the double box, you can see the reference there in the subcontract. 50.2 is far more prescriptive about the application for payment. Again, we can see reference to the scope. It says now, the last line of the first paragraph there, the contractor's application must be in the form stated in the scope. So there's another extra bit in relation to this scope, or what used to be the works information. 50.4 follows other contracts. And this particular change essentially says that the contractor must submit an application for payment. Otherwise, the project manager will only certify the lesser of the following, so the lower of the last two. Whatever the project manager certifies as the amount now due, which of course could include a deduction for delay damages, and the amount due at the previous assessment date. It's the lower of those two items. Now, I know it's going to be an unusual situation where a main contractor doesn't issue an application for payment to the project manager. NEC4, it's even more important that those applications are sent in. Importantly, again, we can see a balance here from NEC. It's also saying now that the project manager's certificate must provide details, okay? And that's expressly set out there in the clause in front of you. Do take care, though, that remember that there is the possibility of a contractor where they haven't issued a payment application and where there's not been a payment certificate from the project manager, the contractor can issue what's called a payee notice in default. Now, the screen in front of you actually shows the relevant clause from the Construction Act, but it's probably easier to describe it with a typical payment chart in front of you. So you can see on the left, an application for payment is issued and received by the project manager, and that has to be done before the assessment date. So you're valuing the works up to that assessment date. 7 days after the assessment date gives you the due date, which is the date on which the project manager's certificate should be produced. Under statute, actually, there's another 5 floating days there for the payer notice. So essentially, so far between the parties, we've had the application issued and the project manager's certificate. If neither of those two documents are issued, then between the payer notice and the pay less notice, that's where the contractor could, under statute, issue a payee notice in default. Of course, there is the possibility for the issue of a pay less notice, which would wipe out everything else. And that would actually stand over the payee notice in default anyway. You'll see on the screen in front of you that the period between the pay less notice and the final date for payment is 7 days. Again, it's very common to see that Zed down to 3 days before or even 1 day before. A change under NEC4 that I will admit made me smile was that when NEC2 and NEC3 came out, they proudly said that this particular contract means that all compensation events will be agreed as we go along, as we go through the job. Well, the most and the least cynical amongst us, I think, probably rolled our eyes and said, yes, whatever. NEC4 have realised that that is not the reality. And what they've now introduced in the contract is a final assessment procedure. Now, I have put quite a lot in the slides here about this final assessment procedure, but it is worth you reading through in detail 53.1. So, the project manager, it's their duty to make an assessment of the final amount no later than 4 weeks after the defect certificate. So, essentially, that's significantly after completion, or 13 weeks after a termination certificate. If the project manager doesn't do this, then the contractor can step in and issue their assessment. So, this is something that I would definitely recommend that you diarise as soon as you know that the project is complete. You know the date when the defect certificate is should be due. You put in a note in your diary to say, let's see if the project manager actually produces their documentation. If they don't, then the contractor can step in and do that for them. And the importance for that can be seen in 53.3. An assessment of the final amount due, issued within the time stated in the contract, is conclusive evidence of the final amount due under or in connection with the contract, unless a party takes the following actions. So, in other words, the main contractor's issue of their final assessment where the project manager hasn't done their job, that could become the final account. Unless, if we're looking at W2, unless there's a dispute referred to an adjudicator, or there's a dispute referred to the senior representatives, or there's been a reference to the tribunal. So, very important that the parties take account of these timescales. And I am smiling with the next one. 53.4 covers the final account. So the assessment of the final amount due is changed if the parties do reach a negotiation or an agreement, or there's a decision of an adjudicator, a recommendation of the dispute avoidance board, which has not been referred to the tribunal. So this is a huge change under NEC4. In terms of compensation events, actually, there hasn't been too much that's actually changed here. The phrases under 60.114 and 80.1, employer's risk has now changed to client liability, but really that's a window dressing change. We do have two new compensation events. Item 20, where a quote for a proposed instruction is not accepted, and 21 for additional compensation events stated in the contract data. Again, really of minor significance here. 61.4, it's really a tweak because this was the case anyway, but essentially this further emphasises the importance of the notification period under 61.3. So just watch out for that new bullet point. However, it doesn't really change what's already in the contract. Possibly there might be some estimators who are also listening into the webinar today. Um, I feel desperately sorry for anybody who has ever tried to estimate under an NEC3 because there are different percentages flowing around here, there, and everywhere. The aim of NEC4 is to make life more simple. But actually, it feels like it's going back to the old ICE or, of course, to JCT. So essentially, now what we have is if you're on main options A and B, of course, you still use the shorter schedule of cost components, or as it's now called, the short schedule of cost components. You can now pre agree people rates. That's a great new thing that's been added in here, that they are actually part of the contract. I have to say, a little bit like day work rates would have been pre agreed in the past. The short schedule of cost components includes subcontractors. So we used to have this rather bizarre way of subbies and stripping out their percentage add ons. But now subcontractors are a separate head, which is great. There's no people overheads, there's no markup rates for manufacture and design. And what we have now is a single fee percentage. There is no separate subcontract fee. That is good, but estimators, just make sure you know which option you are looking at. Um, if you're on option C to F, of course, then you're generally on the schedule of cost components, unless you agree to go for the short schedule of cost components. Again, you can see there it's a single fee percentage. All of those other percentages have been removed. Just a couple of other notes on other issues to be aware of. A few little tweaks there in relation to the contractor's design and the subbies design. This really relates to the importance of copyright and making sure that you get equivalent rights from the subcontractors. So nothing too groundbreaking there. A more important change under 36.1 in relation to acceleration. Under NEC3, the project manager could instruct the contractor to accelerate. Under NEC4, this is only by agreement. So essentially, a quotation is put together and then it's whether it's accepted or not. Unfortunately, the reality here is that the timescales that they've put in the contract, whilst they're realistic for providing a quotation, probably the opportunity to accelerate will have gone by the time that this could kick in. So again, I don't see this as a particularly important change. Finally, just be aware that there are new contracts that are out there. I have no experience of these actually being used yet. NEC4 is really an attempt by NEC to get into the PFI market. So this is a design, build and operate contract. I've given you some notes there on the DBOC contract. Also, there is an alliance contract. Much deeper collaboration is one of the bullet points there. Um, I do remain a little bit cynical to see whether this is actually used in practice, but we will see going forward. That concludes the session and the notes that I wanted to go through today. I am sincerely hoping that Gemma is here we go. She's already got this Q&A thing up and running for me. Questions. We do have some questions. Thank you very much, everybody here. Here we go. Oh gosh, how does GDPR interfere with keeping records? Great question, Joshua. So the records that a contractor would already have in place, okay, well, they would be the same that they would always have, but there just needs to be extra care in relation to issues such as personal information, could be to do with HR, could be to do with payroll information, etc. So in terms of that X15.4, okay, that only relates to keeping records in relation to the contractor's design. However, my view is that that clause should be extended more widely. I was asked a great question last week linked to your question, Joshua. And that question was, do my guys have to disclose the actual evidence of their positive COVID test? And to which my answer initially was, ooh, that's a great question. And I dodged it by saying, see if your guys will actually give their consent to disclose that information. And luckily for this particular contractor, their guys did actually agree to disclose their positive COVID test results. Essentially, the main contractor there didn't believe that they had positive test results, and they thought they were just skiving from this particular site. Okay. Um, Great. So thank you very much for that one, Joshua. Do we have any more? Oh, we do. Main differences between NEC3 and NEC4 in terms of social nudge and partnering, and what are the associated risks? Do you know, I don't particularly see a huge change on that particular issue. There has been a tweak to 10.1 in relation to they've split the clause now, acting in accordance with the contract and a spirit of mutual trust and cooperation. I don't see that there is a massive amount there. Where I think that there could be more information is that because the scope has been widened, then I think that there might be more in relation to whether it's localism and more social issues that actually go into that scope document instead. Really, the risk profile between NEC3 and NEC4, they are actually very, very similar. And I would say I would treat a lot of these as tweaks. NEC itself said it was evolution as opposed to revolution there. Gareth, I think the tweaks are going to be more in relation to that social nudge and partnering. They're going to be far more in the devil in the detail in relation to individual contracts. Great, David. Oh, goodness. Where might I find a more detailed guide or textbook? Right. My starting point would be to say for you to buy the NEC guidance notes. It's quite funny that the guidance notes are longer than the contract itself. But whenever I'm asked a question and I want some reassurance that I've got the right answer, my first point of call is always the NEC's own guidance notes on that. For NEC4, there's actually a set, I think it's of 5 separate textbooks that are produced by NEC, and that would be where I would start. So NEC3 has got one guidance book, NEC4, I think, has got 5, and it's called Managing Reality. Okay. Have we got time for one more, Gemma, do you think?
Oh, I think we've just had that one. There was one more that's just come in that seems to have disappeared. And here it is.
Okay, what's my view as to the balance risk liability between the client and the contractor in a compensation event such as the project manager's instruction? Oh gosh, that is a difficult one to answer. Do you know, I actually think if I take the long view, probably the risks end up as being the same under this contract, under NEC4, NEC3, or the other contracts. In theory, the risk should be less. This issue of forecasting always becomes a problem. My short answer to this is actually this. Bear with me a second. My short answer to this particular issue is that um, it's a longer process and it's a more difficult process under NEC than you would see under other contracts. Okay. Duncan, yes, that's an easy one. By all means, Gemma is recording this presentation. If you wanted a copy of the